Be seated, please. Brown and Brown against the Estate of Ralph Nolan Edenfield. Leineke.
Good morning. May it please the Court, I'm Shelley Leineke on behalf of Brown and Brown and Mr. Lindahl. I'd like to reserve 3 minutes for rebuttal, if I might. We're here today seeking...
I'm sorry, how long did you say for rebuttal?
3 minutes, please. With any luck, I'll have more luck than the prior appellants have had. We're seeking reversal today of a final judgment in a non-jury trial that alleged there was negligent procurement or placement of insurance coverage for a nursing home known as Parthenon. The final judgment was approximately $850,000 plus fees and costs. We're raising 4 issues. First, we assert that the doctrine of judicial estoppel should have totally precluded this claim against my clients because there was recovery from 2 insurance carriers for the very coverage that is being alleged not to have been procured by my client.
Let me,
yes.
If you'll excuse me on that. Take me back to the basics and help me understand how these policies work. And well, let me throw at you my understanding and you tell me if I'm correct or incorrect. The first policy expired by its terms, and take the statute out of the equation for the time being, on September 15th.
Yes, I believe it was September 13th, but yes.
Okay, September 13th. And so there was a 30-day period after that claims could be made against that policy.
Correct.
If the insurance agents had done everything that you believe they should have done, and coverage had been immediately picked up on September 13th, if a claim was made or reported or whatever the proper terminology is on October 16th, or the day after that 30-day window, what would have happened to it?
It would have been covered.
Under which policy?
Under the... Well, if the first policy had been renewed under the 30-day window, if the claim had been reported under that if the claim was reported within the 30-day window, it would have been covered under the first policy.
And if it was reported outside of the 30-day window, but the insurance had been renewed, which policy?
If you assume no prior knowledge by the nursing home, then it would be picked up under the second policy.
So is it, I mean, I guess where I'm trying to understand is what is the significance of this gap period,
well,
if any? I mean, if what you're telling me is that, using my slang, this pre-existing condition, this claim that was out there, if it was reported after or made or whatever the proper terminology is again, after the 30-day period, then it really wouldn't matter whether insurance was renewed or a new policy was placed.
Well, what the problem is there were 2 letters that were sent to Parthenon notifying them of the claim, and the second letter was dated October 23rd, which would have been beyond that 30-day window, assuming the face date of September 13 being the end of the policy. Now, it wasn't reported to either carrier. And so what happened is the second carrier said, well, you should have put on the application that you knew about this claim so we could exclude it, because the second policy didn't go into effect until November 1st. And the first policy is saying the claim was after our reporting deadline. So therefore we don't owe it. But that ignores the issue of the statute extending the coverage.
And I want you to continue ignoring that for a second. I guess what I'm not understanding is how would the situation have been any different had the insurance been renewed on September 14th or 16th or whatever the date would be? How would the processing of that claim been any different if it wasn't reported? If it was reported within the 30 days, it gets paid under Policy 1. If it wasn't reported, Policy 1 doesn't pay it, and Policy 2 says you should have reported it, we're not going to pay it.
If the face amount, or if the face onset date of the second policy had been September 14th, then the claim would have been made within that policy clearly.
But I thought what you told me is that that policy wouldn't have covered it because they knew about it before the policy kicked in.
I'm working from there were two notices that were sent. The first one was, I don't recall the date, early in September. And the second one, the first one was September 19th, and the second notice was October 23rd. So both of these notices came after the facial cutoff date of the first policy. So if the next policy had had its onset immediately on September 14, the claim would have clearly been made within that policy, and there would have been no issue of prior notice or anything of that sort. Because the second policy had a facial onset date of November 1, that's where you get the assertion that it fell within a so-called gap in the policies.
And I guess where I'm going with this is, twofold. One, I mean, in some respects, I see kind of the so what as to all this stuff that happened about a new policy getting placed rather than being renewed. I mean, why doesn't this case boil down to a question of when the claim was reported, which is a finding the trial court X'd out of the judgment?
I think, well, that certainly would have been one way to resolve the issue, but the fact that the plaintiff settled with these two carriers and thereby those two insurers acknowledged that they had coverage, no matter what Edenfield thought or why he said he took less than their policy limits or why they didn't offer policy limits, the mere fact of recovery from those two insurers established that they did have coverage for this claim. He cannot then, under the same set of facts, take the entirely inconsistent position that my clients failed to get coverage because he's already proven that there was coverage. You've got the judicial estoppel theory under Blumberg and Peatmore versus Lane and Lambert, all the cases we cited. In fact, one of the cases specifically says if one defendant buys his way out of a suit, the plaintiff can't contend he wasn't liable. Well, these two defendants, these two insurance carriers, CPC's policy that they brokered and Sapphire Blue's policy that they brokered, both paid. They bought their way out of this lawsuit, acknowledging coverage. You then cannot turn around and say, well, Mr. Brown and Mr. Lindahl and Brown did not obtain coverage. They did. That's judicial estoppel. The carrier has paid, and so the trial court should have at that point said, this case is over. There is no claim for negligent failure to either procure coverage or to procure the right amount of coverage. You can't successfully assert inconsistent positions, and we cited case after case in our brief where that happened. Lambert, for example, a plaintiff sued 3 defendants alleging wrongful death, that they caused the wrongful death, and then after they paid, he said, well, one of them really wasn't a tortfeasor. He paid, but he really wasn't responsible, and therefore I can turn around and take an entirely inconsistent, different position in a subsequent suit trying to get coverage.
Is a settlement for a fraction of the amount of the claim and admission that there was coverage? I mean, people every day in our courts are settling things where they're not admitting liability. I mean, did Lloyd's admit that there was coverage?
No, they did not. But that doesn't
I know you take the position it makes no difference under the Bloomberg case, but it seems to me this was something that was just settled to avoid a risk. That was not really an admission that there was coverage. I mean, to put it another way, if the plaintiff thought there was coverage, they would have insisted on $1 million, wouldn't they?
Well, the plaintiff thought there was coverage.
They had a $1 million policy. They had a judgment for $1 million. I mean, they had the coverage, and they had $1 million judgment, right?
Correct.
Why would they have settled for $150,000 if they thought there was coverage?
Well, they said that was because they were concerned that the carrier was going to win on the no coverage position. However, the carrier paid money because of the claim that there was coverage. There are hundreds of cases out there where a carrier has settled for some amount or dismissed a claim or in some fashion taken a position or paid some small amount, and the cases say, well, you owe attorney's fees, to your client, to the insured. They don't say, well, you only paid a fraction, you only paid a part of it, you really, by dismissing your deck action and not paying anything, you really didn't have any coverage there. Once that carrier crosses that line, whether it's with a baby step or a giant step, and says we are paying something or we are taking some action that is inconsistent with an absolutely no coverage position, they've acknowledged coverage, and the insured is entitled to collect fees and costs. This is the same kind of a thing. Yes, once this payment was made, no matter how large or how small, that's an acknowledgement of coverage. And under Bloomberg, under Lambert, under Pete Marwick, under all of these cases we cited, that is sufficient to establish coverage and end this case under collateral estoppel. My time is running quickly here. The issue of the gap, there was no gap in coverage because of the surplus lines law 626.9201 that specifically says if an insurer is intending not to renew a policy, it must give 45 days notice. Policy 1, the one that was brokered by CRC.
Their argument on that is the evidence in this case showed that there was no intent to not renew.
Correct. Well, CRC, that there's a blurring of lines, respectfully, by Edenfield here. CRC, as the broker, of course wanted to renew. That's the only way it's going to get any money out of this. It's going to make any commission. CRC wanted to renew, but it did not have the authority or permission of its insurance company to do so. It kept sending information, and Lloyd's said, we want something else. It would send more information. Lloyd's would want the answer to something else. The fact that CRC intended and wanted to renew really doesn't matter at all. The Lloyd's carrier never said
does anybody's intent matter? I mean, isn't the way the statute works is unless you give notice 45 days in advance, the policy continues on.
Correct. So the policy 1 continued on until such time as either A, policy 2 takes effect, which is November 1, or B, there is ultimately a notice of intent not to renew sent. And neither of those, well, so there was no notice
here. The
here.
court specifically found there was no notice of non-renewal, right?
Correct. So
that fact alone would be sufficient, in your view, to require reversal under this statute in the finding that coverage was there.
Correct. Correct. The policy 1 remained in effect until November 1, when the Sapphire Blue policy 2 takes effect. Because of that, there is no gap in coverage as a matter of law. So any finding by the trial court that my clients negligently created a gap is wrong.
One last time on this, and I'm sorry to be dense and use all your time on this. This gap in coverage concept, why? I mean, my thinking of a gap in coverage is a point in time where you have no insurance.
Correct.
And, again, putting aside the statute here, this particular claim, they had insurance on. When this claim arose, they had insurance on it. So isn't the issue really ultimately at the bottom of this, when did you report that claim?
Yes, this is a claims-made policy, not an occurrence policy. So the fact that the event occurred in June, when policy 1 is clearly in effect, is irrelevant. The issue is when was the claim reported.
We don't have any findings on that, do we?
Well, we know
that finding.
There's no specific finding in the trial court's judgment, but we know there were those 2 letters sent on September 19 and October 23rd. We know that Parthenon's employees acknowledged that that was sufficient to create an obligation to report. And we know that they asked for reporting forms from my client. We also know that there is no document and no memory of any person that they said, we need these forms so that we can report this claim. It was simply, well, the best the plaintiff can come up with in this is, well, we should have said we want to report the Edenfield claim, and there should have been some notice to Brown and Brown, but there is nothing specific in the record. All we know is they said, hey, we want a reporting form, and it was sent to them, but we never got one back, and there was no report in a timely fashion. So the gap is, it should be a paper issue, because the gap would be assuming Policy 1 could expire on September 13 when it facially ended, and Policy 2 did not come into effect until October 1. But there is, in fact, no 30, 45-day window there without coverage, because Policy 1 statutorily had to continue until the second policy took effect. Therefore, because of that, Policy 1 with its extended reporting period, Parthenon could have reported up to December 1st. It could have waited until then to report under the timely reporting there. And Parthenon failed to do it. So it was not any fault of my clients. There was no gap. The court specifically declined to find that my clients had any obligation to report. So there is no negligence by my client in the reporting. So either this case should have ended through collateral estoppel, or it should have ended because there was no obligation by my client to report and there was no gap in coverage. Either of those allows me to win. Worst case scenario for me, however, would be if the court disagrees with both those positions and says that damages should have been awarded. In that case, the $850,000 number is
Moving into
wrong.
another point, and your time's expired. So that's it.
Thank you.
Good morning. May it please the Court, my name is Dean LaBeouf, and I'm here on behalf of the Appellee, the Edenfields, and Parthenon. Judge Wetherall, I'm going to go out of order on my argument and address something that you raised. There's no need to do a notice of non-renewal under the statute if the carrier intends to renew coverage. That's just logical. If an insurance company intends to renew coverage and is making quotes, as the evidence indicated in this case, they're not under any burden. And the evidence in this case from the underwriter confirmed that.
Let me ask you this. On September 14th,
yes, sir,
or 16th, whatever the date would be, after the policy facially applied,
yes, sir,
they were in negotiations for additional insurance with the original carrier. Did they have insurance or not at that point?
The policy, you were right, expired on September 15th. That was the extension of the policy because of 9/11. Okay? On September 15th, Betsy Barnett, the broker for Underwriters Number 1, said that she got a quote from Underwriters Number 1. She, as a broker, had authority to put that in the form of a quote and submitted that to Brown & Brown. Brown & Brown didn't, however, it appears there was controversy in the evidence, but they didn't place the coverage. Brown & Brown told Parthenon there was coverage. I guess my question is, as a matter of law, there wasn't coverage.
And why does that make any sense under this statute, which seems to be its clear purpose to make sure that insurers are not left in a lurch?
It's a consumer protection statute, but if the insurer, let's get out of Lloyd's and just say this was Allstate. If Allstate said, I'll renew your policy, here's the terms to renew your policy, but Brown & Brown, the agent, doesn't put it in force. Remember, Brown & Brown told Parthenon that they were getting a renewal. CRC says, we got authority from London. We made the quote to Parthenon. Brown & Brown told Parthenon, you've got a renewal. We've got a renewal. Here's the financing agreement. We need the down payment. Parthenon paid $122,122 as the down payment and signed the financing agreement for the renewal. It was Brown & Brown's negligence that blocked the placement of that renewal coverage with CRC. That's what the trial court found. You can't hold CRC or Lloyd's Syndicate Number 1 responsible if they were willing to renew coverage and the agent negligently failed to place it.
I guess where I'm still struggling, under this statute,
yes,
if an insurer, day 45 out, says, we're not going to renew coverage, right, they complied with the statute, how is it any different from them doing nothing on day 45 and leading the insurer to believe that they are going to give coverage. I mean, the statute doesn't kick in, or the statute kicks in either way, doesn't it?
That was a finding by Judge Terrell. Judge Terrell's finding mandates or requires a finding that CRC was willing to replace coverage, or else there would have been a need for a notice of non-renewal. There was no notice of non-renewal, but he didn't oppose any fault on CRC for that. If CRC had a burden of doing the notice of non-renewal, he made the finding that one wasn't done. But the controverted facts in this case were, was it needed? CRC, if they were willing to renew the policy, and there was abundant evidence in this case, Scott Trigg, the underwriter for Policy 1, said, we were willing to renew the policy. There was abundant evidence of that. And as Judge Terrell found...
Let me try this on you one more time.
Okay.
I'm reading paren 3 of the statute, which says, if an insurer fails to provide the 45-day written notice required under this section, the coverage provided to the named insurer shall remain in effect until 45 days after the notice is given or until the effective date of the replacement coverage. I mean, it doesn't say if they don't provide it, the statute kicks in. Whether they don't provide it because they forgot, whether they don't provide it because they want to renew, I mean, how can you read that statute any other way to say no notice of non-renewal, coverage continues?
Let me try. Judge, logically, if this was Allstate, and this is a consumer protection statute. It's designed to protect the consumer so that the consumer isn't left in the lurch where an insurance company at the last minute says, we've decided we're not going to renew you. Okay? So it's got to be based on the facts of the evidence of what happened. If an insurer, like this one, said, I was willing to renew, I issued quotes, I said, here's the deal, this is what we'll renew for. And then the agent, in this case Brown & Brown, negligently tells the insured you have renewal coverage, accepts premiums, deposits it in his account, but it doesn't give it to policy number 1. How can policy number 1 be liable under the statute? They can't. They didn't do anything wrong. If they're willing to renew, they make quotes to renew.
They didn't provide the 45-day notice. That's what they did wrong.
They don't need to if they're renewing the policy. If Allstate
Which
says,
kind
I'll
of goes
renew
back to my original question on September 16th. You're saying by operation of this statute, there was no coverage, period, end of story.
What happened was CRC, there's an email that was admitted into evidence from CRC, and it said, we're extending the policy. We intend to renew the policy. And they negotiated with Lindahl, the agent for Brown & Brown, and they issued a quote. The quote was issued on September 20th with coverage effective starting September 8th. So they said, we'll provide continuous, the record's very clear, we'll provide continuous, uninterrupted coverage for Parthenon with no gap whatsoever. That quote was submitted, it's irrefuted, it was submitted to Brown & Brown, the agent, and because this is surplus lines, there's no ability to communicate for Parthenon to communicate with CRC or Lloyd's. They have to communicate through the intermediary, Brown & Brown. It was unrefuted that they submitted the quote with the underwriter's authority to renew the policy effective September 8th, the original expiration date. Judge Terrell weighed all the evidence and found that Brown & Brown negligently failed to place the coverage.
Okay. Let me shift gears on you
Okay.
here. Her last point on the worst case scenario for her, the $1 million versus and the $850,000 judgment should really be $350,000. I mean, all that you were just telling me was for the policy they were getting ready to place was a $500,000 policy, wasn't it? So if the claim was filed, there was no gap, the claim was made during the policy 2 extension, you would have gotten $500,000.
No,
right?
that's not true.
Okay.
There was competent, substantial evidence in the case that there was a certified letter sent by Wilkes & McHugh to the claims administrator, Roger Strickland, that was received on September 19th, 2001. His testimony, unrefuted testimony, was that he sent that directly to Brown & Brown in accordance with their policies and procedures and the team list. He also testified that he also invoiced for the copying of the file, and the copy of that invoice dated September 25th, 01, was admitted without objection into the record. All of that provides notice of the claim within the first policy. It should be noted that Judge Terrell, when you talk about what he struck it because we added that paragraph that wasn't in his letter, and because he had already made a finding in the preceding paragraph that said Parthenon is without fault in this claim. If Parthenon hadn't given notice in a timely manner, he wouldn't have made a finding that they were without fault. Because if you don't make notice of the claim in a timely manner for coverage, then you've done something wrong. He specifically makes the finding that Parthenon did nothing wrong and that Brown & Brown negligently created a gap in coverage, which resulted in the $1 million verdict.
Under what you're telling me now, the gap is irrelevant. I mean, what you're telling me now is that a claim was reported to Brown & Brown within Policy 1's period.
Within Policy 1's initial period.
And they mishandled it. And there are no findings on that, are there? Other than what you want us to infer from the fact that your client did nothing wrong, you want us to infer a finding that Brown & Brown got notice of this claim within Policy 1's time frame. Is that right?
With all due respect, I'm not asking you to infer that. I'm asking you to follow the competent substantial evidence that Judge Terrell found, where he made the specific finding in paragraph, I think it's 9, that Parthenon did nothing wrong to cause this gap or to do anything to interfere with this claim.
Gap. That's different.
He doesn't say that. He says specifically in the final judgment that I find no fault on the part of Parthenon. It says this gap in coverage was without any fault of Parthenon.
But that's the gap in coverage, isn't it?
But, Your Honor, if you don't report the claim, it creates a gap in coverage. If you don't report the claim in a timely manner, you create the gap in coverage. Obviously, the claim was ultimately served in the lawsuit. There was a lawsuit filed December 1st, which is within the time period that appellant says is adequate under the notice of non-renewal statute. The lawsuit was actually served on December 1st of 2001.
Let's talk about our judicial estoppel
Yes,
argument.
please.
Did your client file suit against insurer number 1?
What happened was, first of all, just judicial estoppel is an equitable defense, and it's designed in accordance with Bloomberg to prevent a mockery on the court. Judge Terrell found that in our original suit, Parthenon filed suit against Lloyd's, who they thought to be one company, Brown & Brown and Lindahl. And they said, we either have coverage with Lloyd's, or if we don't have coverage with Lloyd's, it's the result of some negligence on the part of Brown & Brown and Lindahl. Brown & Brown and Lindahl had the right to have their claim abated if they wanted to. It wasn't mandatory, but Brown & Brown and Lindahl made the election and said, no, we don't want to participate in this lawsuit to determine liability of all the defendants. We want our claim abated. And they had a right to do that. So Parthenon was required to proceed against Lloyd's. And in the suit against Lloyd's, Lloyd's said, we're not one company, we're two. Brown & Brown had placed coverage through the first underwriters. The first underwriters were willing to renew, but for some reason they didn't renew with us, and they switched to Sapphire Blue. Now, Lloyd's told us that the reason they did it was because of commission, and they showed us internal documents on that basis.
I understand all that, but I guess what was the basis of your claim against Lloyd's 1, 2, whatever you want to call them, that Lloyd's, you have coverage of this claim because?
Well, they were both sued in the suit, and our claim was either you have coverage under Policy 1.
Why? How would they have coverage?
Because you need to remember that Parthenon had paid $400,000 for insurance. They were told it was renewal coverage. And then when this claim came in, they filed the claim, and they were told, no, there's not one company, there's two companies. There's Lloyd's 1 and there's Lloyd's 2, and neither one of them's got coverage. The unrefuted evidence in the case was that Brown & Brown never told Parthenon that they were switching carriers.
But you'd agree with me, the only way Lloyd's 1 would have coverage would be, at the $1 million level, would be if that claim was made timely after the facial expiration of that policy.
If the claim was made timely under the 30-day extension period of that policy, there was competent substantial evidence to find that.
Or, by operation of statute, Policy 1's term was extended until this new policy came into effect. And so what I'm trying to get to is what was your argument to
keep it at $1 million?
What did you argue to allege? What point did the case settle, I guess, is maybe the better question, against
It
Lloyd's?
settled when at the end of discovery, we went to mediation, and I can tell you the settlement agreement and it's a confidential settlement agreement, but it was admitted. The settlement agreement says, Lloyd's, both Underwriters 1 and Underwriters 2 said, there's no coverage. And they explained why, and they showed us the two policies. And they said, however, there were two New York law firms representing Lloyd's, plus a big firm in Jacksonville, plus a big firm in Orlando. And they said, it's going to cost us more than $120 and $30 to destroy you at trial and on appeal.
But counsel says none of that really matters under the Bloomberg case. So what's your best distinction between your case and the Bloomberg case? Why are they different?
Because Bloomberg, in the preliminary case for coverage, went to trial against the insurance company. And it went to verdict. And at verdict, the jury found that there was coverage.
So the distinction here for you is the settlement contains no findings at all.
Absolutely.
We typical settlement, we admit nothing.
Absolutely.
Okay.
And the other cases that they cite with regard to insurance companies, I think Uterlink and another case, those are cases where the insurance companies filed deck actions to say there's no coverage in this case, and then they turned around and settled the underlying claim, and the appellate court said, wait a minute, that's the equivalent of a confession of judgment because you provided the benefits afforded under the policy, and you're entitled to attorney's fees. They're all attorney's fee cases.
Judicial estoppel based on the act taken by the court, then, as opposed to like an inconsistent action taken by a party?
Well, you know, I think
you're saying this depends on the
it's all fact specific. It's and judicial estoppel is an equitable remedy to say, was Brown and Brown abused in some way? Well, no. They had the right to get a set-off for the $150 that was paid. They had a right to continue to say there's coverage under Lloyd's. And Judge Terrell made the finding that there wasn't. So there was no prejudice as existed in the other cases.
Here's what my concern is. As I understand judicial estoppel, it's not to protect a party. It's to protect the system.
Right.
And you could have been making a colorable argument to Lloyd's saying you have a responsibility to pay this claim because your coverage didn't end.
Right.
And if you were making that argument and are now coming before us and before the trial court making the exact contrary argument, that is exactly what judicial estoppel was designed to prevent. So I guess I know you wouldn't be doing that. So what I assume your only argument to Lloyd's 1 was to why they have claim is because the claim was timely reported within the 30-day period. I mean, that's the only way you could do it without making inconsistent arguments.
With all due respect, what Judge Terrell found and what we alleged was we didn't know. We knew that we paid $400,000 for coverage, and either there was coverage under Policy 1 or Brown & Brown was negligent in failing to place that coverage, creating the gap, and we were entitled to the benefit. That's what we allege, and that's what Judge Terrell found in denying their motion for summary judgment. In their motion for summary judgment, they acknowledged in their memo that there was $1 million in coverage and Policy 1 would be the one that applied.
If
Thank
counsel
you.
wins on point 4, and I'm not suggesting that she will, I have no idea, is the $150,000 that Lloyd's paid set off against that $500,000, or was it intended to be set off against only the $1 million policy that Lloyd's had?
Well, you know, it was on the $1 million. Thank you.
We'll allow you a
Will the
minute.
court extend me a moment, please? I'll try and... Whatever they said in the settlement doesn't make any difference. Dionysus versus Palm Beach years ago said, however they characterize the terms of the settlement doesn't bind someone else. CRC was making quotes. It's an insurance broker. It didn't have authority, though, to bind anyone. No one would give more than $500,000 for the renewal, so worst case scenario, that's the maximum damages, less the $150 leaves $350. The court did not say Parthenon was free of fault, only that it was free of fault in creating any insurance gap. My client did not create a gap, and the court also did not hold that my client had any obligation to notify anyone of a claim. There was no gap in coverage. Judicial estoppel does apply. The suit against Lloyd was saying, you owe us coverage, and that's why that was paid. Respectfully, my client should win on either of the first 3 points, or at a minimum, the damages should be reversed. Thank you.